Masabumi Kikuchi was a Japanese jazz pianist and pioneer in electronic music, famous for his eclectic approach to composition. In the 1970s, he moved to New York City and set up his equipment in a home studio. Then his landlord embarked on a major renovation project. The resulting cloud of dust gave rise to the case Minjak Company versus Randolph. In 1976, Kikuchi and Diane Randolph rented a Manhattan loft from Minjak Company. Kikuchi used about two-thirds of the loft's 1,700 square feet as a music studio. He kept his instruments and his expensive electronic equipment there and used the space to compose and rehearse. He and Randolph used the rest of the space as their residence. In 1977, the fifth-floor tenant opened a spa equipment business. This store contained working displays of jacuzzis and hot tubs, which tended to overflow and pour down into Kikuchi's apartment. Between November 1977 and February 1982, Randolph and Kikuchi experienced at least 40 leaks, which drenched their bedroom and closets and saturated Kikuchi's grand piano. Randolph and Kikuchi complained to Minjak to no avail. In 1978, the spa business sandblasted the walls. Sand seeped into the loft, getting into Randolph and Kikuchi's bed, food, and eyes, and onto Kikuchi's equipment. In 1981, Minjak decided to renovate the entire building. He removed the elevator shaft on Randolph's side of the building. Workers dumped debris down this shaft, raising huge clouds of dust, which joined the sand and water in the beds, food, toothbrushes, and instruments. Kikuchi and Randolph developed eye and sinus problems, sore throats, and nausea. They put up plastic sheets to keep the dust out, but the workers tore them down. Kikuchi had to keep his equipment covered at all times. His musical studio became effectively unusable from the time this activity began in 1978. In 1981, he started paying Minjak only one-third of the rent, on the reasoning that he had lost the use of two-thirds of the apartment. In 1983, Minjak sued Randolph and Kikuchi seeking back rent. Randolph and Kikuchi presented the affirmative defense that, due to constructive eviction, they were entitled to an abatement of two-thirds of the rent. They counterclaimed for breach of warranty of habitability. The trial court awarded Randolph rent abatement on a theory of constructive eviction, another abatement for breach of warranty of habitability, and punitive damages. The appellate term reversed. It held that because Randolph and Kikuchi hadn't abandoned the apartment, constructive eviction wasn't a defense to nonpayment of rent. Randolph appealed to the New York Supreme Court Appellate Division.